We begin Unit 11 looking at international data privacy. Up to now, we have focused on the laws governing data security, privacy, and compliance in the United States. And in the United States, as we've seen, the privacy framework is sort of a patchwork of state and federal laws and case decisions that are essentially varied by jurisdiction. The European laws and those of many countries have taken a more central approach to defining their privacy laws by their government bodies. In this unit, we'll address how some of these countries, the European Union, Canada, China, Mexico, and Japan, address privacy. There are two concepts that are similar across many countries. That is a concept of a data controller and a data processor. The data controllers help determine precisely how data are used, distributed, shared, collected, and processed, while the data processors process data under the direction of the data controller. The EU comprises 28 member nations, and this was subject to the decision on Brexit, but 19 of which have adopted the euro. In 2016, the EU replaced their existing privacy legislation, the Directive 95/46/EC, with the General Data Protection Regulation, or GDPR. The implementation date was May 25th of 2018, so the GDPR is the law of the land at this point. The most fundamental statement on privacy in the EU is that they view privacy as a human right. And the GDPR applies to the personal data processing of EU residents, whether the processing takes place within the EU or anywhere else in the world. So, personal data is any information relating to an identified or an identifiable natural person. And a natural person can be one that can be identified directly or indirectly by reference to an identifier, such as the name, an identification number, location data, online identifier, or one or more other factors like physical, physiological, genetic, mental, economic, cultural, or social identity. It does not have to include the individual's name, just identifiability. So the GDPR applies to two types of companies, the controllers and the processors. Controllers have the responsibility to ensure that the processors are implementing the appropriate technical and organizational measures that meet the GDPR requirements. It's important to understand whether your company is a controller or a processor. So, for instance, a large retailer may be a controller since they collect data on users and employees. Their third-party payroll, HR, and credit card processors may, in fact, be classified as processors under GDPR. The general principles of GDPR are lawfulness, fairness, and transparency, purpose limitation, data minimization, accuracy, storage limitation, and integrity and confidentiality. And the processing of personal data is lawful only if the individual has provided consent to processing of personal data. The individual is subject to a contract for which processing is necessary. Processing is necessary to protect the vital interest of the data subject. Processing is necessary to perform a task in the public interest, or processing is necessary for legitimate interest of the data controller or the third party. Additional restrictions on the processing of special categories of sensitive data, which reveals either a racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, processing of genetic data, biometric data, health data, and sexual orientation. So you notice here they have included processing of genetic data, which I posed the question in the last unit about the biometric data being collected and being referenced in the Illinois biometric law. The individual must give explicit consent to conduct the processing. The processing must be transparent. It must provide the data subject with a number of different pieces of information: contact information for the data controller and data protection officer, purposes for the processing and interests of the controller and the third party, recipients or categories of recipients of the personal data, whether the data controller will transfer data to another jurisdiction, the length of time the personal data will be stored, the right to request access to and erasure the data, the right to withdraw consent, and the right to complain to a supervisory authority, whether the data are required by statute or contract, and the existence of automated decision-making such as profiling. Additionally, in Article 17, the EU expresses the right to be forgotten, a qualified right to request data controllers erase personal data if one of these conditions exists. The personal data is no longer necessary to serve the purposes for which it was collected or processed. The data subject has withdrawn the consent that allowed the personal data to be collected. The data subject objects and the controller fails to demonstrate compelling legitimate grounds for processing. Personal data was processed unlawfully. The EU or member state requires erasure under a different law, or personal data was collected from a child under 16. The controller is not required to delete the data if it's necessary for processing. The GDPR does not prescribe specific data security provisions. It must implement the appropriate technical and organizational measures to ensure a level of security appropriate to the risk, however. Suggestions for some technical approaches are encryption and pseudonymization of the personal data. That can be obfuscating certain fields like we do with credit card data, could be using hashing to protect the data, etc. Encryption. So, safeguarding the ongoing confidentiality, integrity, availability, and resilience of processing systems and services is another suggestion and another key technical approach, as well as regular testing of technical and organizational security measures. For data breach notification, the controller must, without undue delay, and if feasible within 72 hours, notify government regulators and provide the following information: the nature of the breach, categories and number of data subjects, categories and number of personal data records involved, the name and contact details of the controller's data protection officer, the likely consequence of the data breach, and measures taken to mitigate the adverse effects of the breach. There's no real specified time limit to notify the data subjects of the breach, however, and notifications to individuals should have the same information as sent to the regulators. Exceptions to the need to notify individuals are when the data was encrypted or anonymized, when the controller took action to ensure that high risk to data subjects will not materialize, when individual notices would involve disproportionate effort. The controller can provide notification by public communications. A particular concern to U.S. companies is a restriction on transferring covered data to a third country. Data must be deemed by the European Commission to have adequate protection for personal data. There's only 10 companies that have been deemed adequate. Safe Harbor was a self-certification that companies have compiled with specific data protection principles, but this was struck down in 2015 and replaced with the Privacy Shield in 2016 with the following provisions of notice, data integrity and purpose limitation, choice, data minimization, security, access, recourse, enforcement, liability, and accountability for onward transfer.